Welcome to the District Court Show. This is a production of the 10th Judicial District. I'm Judge Steve Halsey, and my co-host is Judge Elizabeth Strand, and we're judges in Wright County, 10th Judicial District, chambered in Buffalo. And the topic of this program is going to be the child support law, and I've got two of the child support magistrates in our district. And first of all, Jill Prohofsky. Welcome, Jill.
Thank you.
And also Kim Brandell, a child support magistrate. Welcome, Kim.
Thank you.
Why don't you tell our viewers about a little bit about your legal training and your experience and when you became a magistrate. We'll start with you, Jill.
I went to the University of Minnesota Law School, graduated in '93, and I worked for a small firm for a few years, and I was practicing on my own for a few years exclusively in the area of family law. And then I ran a low-fee family law clinic that assisted people on a sliding scale and helped self-represented people prepare themselves to represent themselves in court. And then I became a magistrate in 2002, and I've been doing that ever since.
Okay, and Kim?
I graduated from Anoka High School in 1970. In fact, I attended high school with Judge Halsey.
Yeah.
I was in the military, and then I attended undergraduate school at the University of Minnesota. I went to law school at the University of North Dakota, and I graduated in 1981. I was in private practice for 2 years, and then I was with the Sherburne County Attorney's Office for 6 years. Went into private practice and was hired as a magistrate in 1994. So I've been a magistrate for more than 20 years.
Okay. And there's been some change now, and you're both going to be employees of the state of Minnesota instead of, like, as so-called independent contractors. And Jill, you're going to be working full-time, I believe?
Yes.
And Kim, you're going to be working three-quarter time or part-time?
Correct, three-quarter time.
Let's go right into the basics. A couple of basic definitions. First of all, the definition of child, which would seem to be pretty easy, but is quite a complicated legal concept. So why don't you talk about that, Jill?
The legal definition of child is someone who is 18, up until the age of 18, or if they're still attending high school or what we call secondary school, up until the age of 20, whichever comes later.
Okay. And then the definition of child support following that up, Kim.
Well, child support can be many different things. In essence, the cases that we deal with have medical support, basic support, and child care support. Medical support is a parent's duty to provide medical and dental insurance, to contribute to the costs of the insurance, and to pay unreimbursed medical and dental expenses incurred for the benefit of the child. Child care costs are allocated between the parents based upon their ability to pay child care. And basic support is the support that a non-custodial parent would pay to the custodial parent to pay for things like housing, food, and the typical everyday costs of raising a child.
Okay, Beth.
It is your job to calculate all of those things you just mentioned, so people appear in front of you in court. And so how do you make these calculations? What information do you need?
The primary information that we need is people's gross income before taxes, before any deductions, and we use pay stubs, tax returns, or W-2s to ascertain that information. Because in Minnesota now we have a sliding or an income comparison. So it's presumed that both parents will contribute to the support of the child, and we plug both of their incomes into a calculator. There are a few other factors, maybe whether they have other children in their home, but the main thing is we look at their incomes, what is an appropriate level of support, and then between the two of them, how should that be shared?
Could you define what is income?
Income is any periodic payment that you would receive. So for most individuals, that is your W-2 wages or your pay stubs that you get from your regular salaried or hourly job. It can also be self-employment income if you own a business, and then that's a little bit of a different definition, and those are basically your business profit less reasonable expenses. And it can also be other periodic payments that people might be entitled to, and often those are things like disability benefits or some sort of recurring monthly payment that an individual would get.
And if I could follow up, is other child support received income?
It is not.
How about spousal maintenance? Is that income?
Spousal maintenance is income.
Okay.
Let's talk about a few more definitions. Obligor and obligee, people probably don't know what those are. Kim, could you explain what those terms mean?
Obligor is typically the person who's required to pay child support. Obligee is the person who receives child support. Typically, the obligor is the non-custodial parent, or it could be a joint physical custodian who earns more money than the other joint physical custodian. The obligee is typically the custodial parent, or custodial parent.
And I think one misconception is if somebody remarries and is divorced from the mother of their children, for example, that the new spouse's income is going to be included. And is it included in the income calculation?
No, it's not.
Okay. All right. So let's assume there's a child support order. How long does that go until, as far as the child's age or whatever?
The obligation is typically paid so long as the child is in high school up until age 20. The support obligation can be continued beyond that date if the child is incapable of self-support. So if there's a disabled child who's not able to maintain and support themselves, the support obligation can continue beyond age 20.
Okay. And then Jill, let's talk a little bit about the process. It's called the expedited process, correct?
Yes.
How do parties get involved in that process?
There are two main ways to get involved in the expedited process, and the first would be if the custodial parent or primary custodian is receiving any form of public assistance, cash assistance, if they're getting help with public health care coverage, or if they're getting some daycare support or what we call child care assistance, then they're automatically in that process, and the county is involved in their case and brings that on behalf of the public interest. The other way a parent could get involved in the expedited child support process would be to make an application for services from the county that they live in. So they're not receiving public assistance, but they want the county's help with collection and enforcement.
Right. And if the person receiving the support, the obligee, applies for collection services, then the obligor, the payor, they really don't have a choice. It's going to be withheld from their pay. Is that true?
Correct.
Okay.
It's a federal program. It's a requirement.
And so then they would be in the expedited process, which most of those cases would be heard by magistrates as yourselves. What kind of cases would not be heard by the magistrate then?
Magistrate would not hear disputes about custody or parenting time, orders for protection, or any of those other areas of family law that don't have to do with child support in that 4D process, so that you've come in one of those two ways.
And there are some child support cases that we cannot hear.
Okay.
Before a case can be before us, it needs to be a 4D case. And as Jill said, that's typically a case that involves public assistance, or one of the parties has asked the county to implement income withholding. Those are 4D cases. If there is no public assistance involved, and if the county is not involved in collecting child support, it's not a 4D case. So there may be a dissolution decree that requires someone to pay child support, but if there is no public assistance and if the county is not providing collection services, they may appear in front of us. But if they do, we can't decide the case because we don't have the authority or the jurisdiction to make decisions unless it's a 4D case.
Okay. Beth?
Kim, describe what you see when litigants appear in front of you. What happens during these hearings? Do most people appear, for instance, with attorneys? What type of information do you receive, and then what do you do with it?
Well, every case is different. When I was first appointed an administrative law judge, which is what we were before 2001, I was a little bit intimidated by what I was asked to do, but I thought that if I handled a couple of calendars, I would have heard everything that there was to hear, and thereafter everything would be cookie cutter and simple. I've been doing it now for 21 years. I do 2 calendars a week. In the past, I did 3 or 4 calendars a week, so I've had thousands of calendars, and I can tell you that in Anoka today, I had 8 hearings, and in probably 4 of those hearings, I heard questions and saw things that I've not seen before. So my anticipation that things were going to become routine and cookie cutter was wrong. I see all kinds of different cases, as Jill does. We see parties with lawyers, we see parties not with lawyers. My guess is about 1/3 of the cases that I see, the parties, when I say the parties, I mean the petitioner and the respondent, are unrepresented. In most of the cases that we see, public assistance is involved, so there are 3 parties. There's the petitioner, there's the respondent, and the county. The county is an independent participant in the proceedings, and the county, if it participates in the proceeding, is always represented by an assistant county attorney. So in about 90% of the cases that we see, there is at least one attorney, and that is an assistant county attorney. Other cases, parties are represented or they're not represented. The issues are always different. The information that we need to resolve the issues, always different. As Jill earlier said, our focus is, what is the income? We need to determine what the gross monthly income is, and we create a record during the hearings that we hear. And when I say when we create a record, what I mean is people are sworn, they provide us with testimony, and they provide us with exhibits. When I was an assistant county attorney doing child support, all of those cases were resolved by affidavit. There was no live testimony. And in about 1993, they changed, or 83, I'm sorry, they changed the process so that people provide evidence, they provide testimony. So we gather evidence, we gather documents to determine the parties' incomes, if there are child care costs, what the child care costs are, if there's insurance, the cost of the insurance, and then we take that information, determine what appropriate findings of fact would be, and then we issue an order assigning responsibilities for the support obligations.
And if they don't like your order, then what happens, Jill?
If they don't like our order, they can either appeal it directly to the Court of Appeals, or they can ask that it be reviewed either by us, the magistrates that have heard the case, or by a district court judge.
And then the district court judge just gets basically the file and not the recording of the proceedings?
The district court judge can listen to the
Okay.
recording, or sometimes people will choose to order a transcript.
Okay.
But usually it's a paper review based on the record that Kim was
Okay.
talking about that was created.
What's the quality of the evidence that you're getting? I'm sure there's a wide range, but are people often not bringing anything and they're just telling you, I make so much an hour, no tax returns, no pay stubs, no nothing?
I think the problem that I see is not that they don't bring enough, but they bring too much.
Oh, okay.
I mean, we'll typically have 8 to 10 cases on a calendar, and typically 6 to 8 of them are going to be disputed, where there's going to be a contested hearing. In the 10th district, most of our calendars are morning only so that we can draft orders in the afternoons. So each case has maybe a half an hour of our time. And sometimes people come with a whole lot of information and they want to talk about things that...
Everything.
That's right.
No visitation. I want
That's
to
right.
talk about that.
That's right. And they oftentimes do want to talk about things that have absolutely nothing to do with the issues that are presented today. They want to provide us with some historical context, and sometimes it's interesting, but it might not help us make decisions in our particular cases. But they typically come with the information that's necessary. The most important stuff for us, of course, is documentation that would evidence the income that's being earned and the costs that are being incurred in insurance and child care and maybe monthly living expenses.
I would say as there have been more shows like this and more self-help clinics, that the people that come to court have become more educated and more aware. And so we see a lot of people that are very prepared and have all of the documents.
Okay.
And
I'm going to interrupt you there. I'm getting the high sign. We're going to take a brief break for a public service announcement, and we'll be right back.
Wake the sun, tell him that I've begun to dream of things to come, and tell the trees not to look for me. I'm going the sun, wake the sun, wake the sun, wake the sun.
I eat healthy enough most days. I don't need to exercise, right?
False. Less than 5% of adults participate in at least 30 minutes of physical activity each day.
I don't have time to exercise.
False. The average American watches over 5 hours of TV a day. Plenty of time to hit the gym.
I walked to class today. That's enough exercise, right?
False. With at least 20 minutes a day, exercise is known to boost energy, reduce your risk of disease, and give yourself an overall better mood during the day. You're always going to have an excuse to not exercise, but why let that get in the way? Get off the couch, get outside, and have fun.
Hey!
What?
Dude, slow down.
You don't act like this in real life. Why would you do it behind the wheel?
What?
Minnesota law enforcement agencies are on the lookout for aggressive drivers. You could be fined or possibly lose your license. Are you that guy? Learn how to deal with aggressive driving at mndot.gov/aggressive driving.
Hey, come on, can't you go any faster?
People think I'm trash, but they're wrong. Today I'm just an aluminum can, but one day I could be a stadium.
Welcome back to the District Court Show. I'm Judge Steve Halsey from Wright County. Our topic is child support law, and my guests are two child support magistrates, Jill Prohofsky and Kim Brandell. And Beth, take it away.
We were just discussing all the information you receive from litigants pro se or through attorneys and through the county. How do you perform these complicated math problems?
Well, in the old days, we performed it with a calculator, but now there is a computer program or an online web calculator that is housed with the Department of Human Services. People can look that up before coming to court and run some preliminary numbers themselves. But there's a web calculator, and you input the information. Excuse me, how many children are there? What are the incomes? Do they have any other children? Do they have any other support obligations? What does it cost for medical insurance? What does the daycare cost? And the computer kicks out a suggested or guideline number, and we take it from there.
What if the person is unemployed, seasonally employed, erratic income? Kim?
Well, every case is different. I try to determine either what someone earns, and if they're not earning what they're capable of earning, what they're capable of earning. In most instances, people have jobs, full-time jobs. They work 12 months a year 40 hours per week. With those people, it's easy to determine what their gross monthly income is because it's reflected in their paycheck stubs, or it's 40 times their hourly rate. There are those cases where someone is working less than full-time, someone who is working sporadically, someone who works a seasonal job. In those particular cases, at least what I try to do is determine what their potential is. So if they're working 20 hours per week and they're trying their hardest to work full-time, and for some reason they're not able to find full-time employment, I may determine that their gross monthly income for child support purposes is what they're currently earning, so 20 times their hourly rate. There are some people who decide to work 20 hours per week and they're able to work 40 hours per week, and those people have jobs available to them. In those cases, I will oftentimes find that the person is voluntarily underemployed, and then I would impute income to them. And when I say impute income to them, what I mean is I would make a determination of what it is that they could earn if they tried their hardest to find full-time employment. And then their support obligation will be based upon the income imputed to them. And one thing I want to say, and I think it's important for the people who might be watching, our process is very user-friendly. We're not as formal as your courtroom. So when people come into our courtroom, we help them provide the information necessary so that we can issue an order that addresses all of the support issues. So if people don't feel comfortable in the courtroom, that's understandable, but they have to understand that by the end of the hearing, they will have been given an opportunity to provide us with information, and if they're reluctant to do so, if they're nervous, we'll help them through the process so that we ultimately gather all of the information necessary, and the information is going to be accurate because we want a support obligation that is enforceable and doable. We don't want people to not be able to provide us with information and then we issue an order that is unrealistic, because that doesn't make any sense to order someone to pay $600 a month if they only have the ability to pay $300 per month. And so one of the reasons that we don't have as many lawyers in our courtroom as you do is because we do help the people from behind the bench. And that doesn't mean that we're going to provide legal advice, but it means that we're going to help them provide us with the information necessary so that we can make an appropriate decision.
And there's a lot of information on the state court website. Not only the calculator, I've found all kinds of 4 or 5 pages of definitions of terms that are used in the child support process. Do you keep the record open, Jill, if there are things you need they don't have?
If there are things that people don't have, but it's information that they could easily obtain, if they forgot to bring their pay stubs, or if they need to check back maybe with HR to find out how much they actually are paying for insurance, we'll ask them, how long do you think it would take to get that information together? And usually they'll say a week or 10 days, and then very often we'll leave the record open for an additional 2 weeks or so in order to allow them to gather that information, because we want to have the best information and make the right decision.
Okay.
Can you ever work outside of the guidelines? I think there's something called deviating from those child support guidelines. And do you hear agreements? Do people come in with an agreement to change your orders? If so, what if they don't want to go along with what the law tells you you should do?
Frequently, people do come in with agreements. We have a fair number of cases where by the time people get to court, one party has prepared all of the paperwork, served it on the other, and they've usually talked several times, and then sometimes even in the hall the morning of court. And parties will often come in and just say, well, we've already decided what we want to do. And as long as there is not a substantial public interest, like cash public assistance in place, people have a lot of latitude to make agreements that work for them. And probably the most common one that we see is that maybe someone will pay a little bit less in child support because that parent is also picking up something else. Like maybe they're the travel hockey parent and they're taking the kid to all the tournaments and they're paying all of the travel ice fees, and that's not something that we can plug into the calculator, but that's important to that family. And so as long as they're not getting cash public assistance, if families have those agreements, then for the most part, we're going to honor those.
That was a question I was going to ask, and it's frequently asked when parties particularly don't have lawyers, is, well, in addition to the child support, I want him or her to pay half of the hockey camp, like you said, half of the ballet lessons, half of this or that for extracurricular activities. Are you able to order that, or is it just strictly the child support amounts?
That's not something that we can order. We just order a set dollar amount because the child support agency collects that, and it needs to be a set dollar amount, but people can agree to that.
Well,
It's
then
a
the
matter
next
of
one was,
enforcement.
as a practicing lawyer for many years, this was a real bugaboo with me, and that is the agreement to pay for college. Can you order that?
No. No. And I don't think we can enforce it either.
Yeah.
I mean, as you know, parties can agree to that as part of their dissolution, and district court can order that someone contribute to the costs of college education, but no, we cannot order that.
Jill, once you get a child support order, a number, is that set until the child or children emancipate or age out of it? Or can people come back to court and change that amount based on a change of circumstances?
People can come back to court based on a change in circumstances, and a lot of times over the lifetime of an order or a lifetime of before the child becomes an adult, that will get adjusted a number of times. People change jobs, they get raises, the child's daycare usually decreases as they age, medical insurance changes, and the process is user-friendly, and it's always open for people to come back and make those adjustments.
How about cost of living adjustments? Cost of living has been almost zero for several years here, but what happens if in the future that goes up significantly?
Well, there is a process in place whereby support obligations can be adjusted to reflect changes in the cost of living for the Minneapolis-St. Paul area. Mm-hmm. The state will calculate what the cost of living adjustment is for a 2-year period of time, and then they will notify child support obligors that their child support obligation is going to be automatically increased to reflect the changes in the cost of living. I think this year it was a 3.2% for the last 2 years. And after a child support obligor is told that his obligation or her obligation will be increased to reflect changes in the cost of living, they have the right to contest that. And if they choose to contest that, then there's a hearing before a magistrate, and the magistrate will determine whether the obligor's income has increased commensurate with the cost of living adjustment. So if the cost of living adjustment suggests a 3.2% increase and the obligor's income has increased by 5%, the 3.2% cost of living adjustment is implemented. If the obligor has experienced no increased income, then the cost of living adjustment is not implemented. But if the obligor's income has increased somewhere between 0 and 3.2%, it can be increased to reflect the increases that he or she has experienced.
Been given the high side. We're about out of time here, so thank you, Jill Prohofsky, Kim Brandell. Very, very interesting. As I said, there's a lot of information on the state court website, and we will post that at the end of the credits here. So thank you for watching the District Court Show, and we'll see you again next time.